Hello, and thank you for watching our channel. Today's video is rather unusual. We're talking about medical inadmissibility. And the reason I address this issue again and again, at least once a year, because the government is changing policies and approach to medical inadmissibility, and definitely new numbers are published right now regarding admissibility threshold. We will address this and more issues. Please watch until the end because it's quite a long video. A few minutes we will dedicate to addressing official position of the government of Canada on the medical inadmissibility issues. I will walk you through a basic approach from the government, and then I will tell you something what we do at AnyVisa to address this issue and help clients to overcome it. So let me share something that you're probably familiar with, but again, it's like a Sherpa sharing map with you, how to cross the mountain ridge. You know the map, you see it, but is it really helpful? Of course, we know the destination, but how to overcome it until you hit the ground and you go through the mountain ridge yourself with Sherpa's help, you cannot actually say that you feel comfortable. So let's walk through this together. And I hope before we start, I would like to address one teaching that Zen Master told me once. He said something wise. It resonates with me, my approach to life. Pain is inevitable, he said, but suffering is optional. And I think that is something that we have to keep in mind about medical inadmissibility because certain issues are pain that is inevitable. It happened. It's your life. It's your children. It's your parents. It's your spouse. Something happened and you have to deal with this. But suffering is optional. And how we treat our attitude towards sickness or medical condition that may prevent or complicate your transition to Canada, this is up to us. So let's walk through this together. I really hope that it will help you if you're really touched by this problem. If not, at least share it with someone you know who may benefit from this. So this is official page of the government website on medical inadmissibility issue related to immigration to Canada. I encourage you to watch these materials they publish, read it, and at least explore the page if you think it may touch your life, your application process, especially if you're already in process and it's kind of inevitable that you may face it. Generally, all this admissibility criteria divided in three areas, and I will walk you through briefly. A danger to public health is prescribed here, and it's a very rare situation when you have active infectious disease and you can actually affect other people in Canada. Definitely, it may be discovered if you not already know about it, which you have to tell us up front. Medical examination usually discover those problems, and you may be requested to address it. But normally, I can tell you, danger to public health is not able, you're not able to overcome unless your situation is treated, and then you will be asked to pass additional tests and maybe other specialist reports in depth. Danger to public safety is something different than public health. Public safety is something that you probably understand yourself, but worth repeating. It's a sudden incapacity, like loss of mental abilities or physical abilities. Something can happen to you suddenly, and then you fall prey to circumstantial situations, and you can be unpredictable in terms of violent behavior. So those things are very seriously treated by the government of Canada. Well, one person told me we don't need more crazy people in Canada. Sounds harsh and very unhuman, but truth being told, that's kind of correct statement. We try to not to allow people who can endanger public safety to come to Canada for permanent residency. Now, the most popular quote unquote word is excessive demand. Excessive demand in general means that you will come to Canada. You probably will be able to overcome this, and we will talk about that. But you have to qualify for that. So excessive demand, what it means, your condition is considered to cause an excessive demand if the health or social services will be needed to treat your health condition, and services needed to treat and manage your health condition later. So those things are, if you ask me, probably 99% of our potential issues with medical inadmissibility. They all about excessive demand. Because if we're able to consider public safety or public health issue, we definitely address it before people apply. Excessive demand is something we can deal with this. So first, how to identify a threshold for excessive demand? Excessive demand for 2025 was fixed at $135,810 over 5 years, or $27,162 per year, which is technically a low income cutoff or legal identification of cost of living in Canada. Why they put this number? Well, short answer, because they can and they need to put some number on threshold. How they identify this number, I already said, it's legal. How they apply it, it's a different matter. So let me address this separately. But before we do that, it's worth to mention that some exemptions apply. Definitely, if you come in as refugee or dependent on refugee or protected person, which technically is the same as refugee, and if you don't know the difference, they combine under asylum category. And definitely, if you're sponsored by a family member as a dependent child or common law spouse, you definitely not falling under excessive demand, because in this case, it's a given. So it's exemption, and people, if they sponsor it, can overcome excessive demand easier. They're not off the hook. Some additional examination will be required for sure, but at least this threshold will not apply. How government notifies you and people regarding a situation with medical conditions? Procedural fairness letter, because this is a reason for people to be rejected. That's why, according to law, procedural fairness means every side must express their opinion or has a right to present their arguments towards the procedure. And procedural fairness is granted with clear identification of reasons. At least we expect government to provide exact reasons. And definitely, you may be requested to provide additional medical diagnosis. If you, for example, from the time of medical exam, your situation improved. We have multiple cases with some treatment of tuberculosis or some other suspicious X-rays or other MRIs and other exams that cause concern, and procedural fairness letter was issued, but then additional examination eliminated those concerns, and the people were treated well and then returned to the proceeding. Kind of medication may cause a lot of concern because some medication is expensive. So in this case, of course, it may be very decisive factor, and that's where exemption kicks in on threshold amount. And last, probably component of the cost is service that you require from the public, because, for example, if you switch from medication but you require regular checkup or observation, that may cost public service some money, and that's exactly what they try to prevent. And if you're able to cover that cost, look forward to spending or presenting your ability to cover certain costs. So basically, how to calculate this cost in comparison to what you face? It's rather simple. I can give you a little secret here. If your expenses on medication or services in calculation of Canadian cost equivalents lesser than threshold, and you have money to show, then you okay. I'm not saying you 100% okay. Nothing is 100% guarantee, worth to remind. But at least if you're not exceeding that threshold, then you okay to proceed and present your arguments. We have cases, well, long ago, I remember one dramatic case when the guy actually went as far as trying to explain to me that divorcing and giving up his custodianship over the child would resolve the situation for him to move to Canada. Well, first of all, I refused to serve the client after that statement because we had very heart-to-heart discussion. I realized that, well, unfortunately, the real reason is like completely beyond the moral and ethical levels of my services. And I said, I cannot represent a person like this. But it was devastating because he didn't have enough money to show a threshold. And at that time, it was about $70,000. So now it's 135 and 27 plus a year. So technically, you see the point. You see how to calculate. Worth to mention, speaking of procedural fairness letter, don't think that you have enough time to do this. If you have just 90 days, normally request is granted for medical examination, for medical inadmissibility for 90 days. And if you watch other videos about procedural fairness letter, you probably saw me talking about 30 days given, 15 days given. It all depends on the cause of procedural fairness letter. In this particular case, I can tell you that this is almost given. If it's medical inadmissibility, we're talking about 90 days. Is it enough? Well, that's when we ask people to be proactive, confront the situation, openly discuss it with us, don't hide it until the last moment. We cannot let you go off medical inadmissibility just by saying so. Additional work required. Normally, it does not cover it by our retainer agreement, of course, because it's exceptional situation. But just like criminal inadmissibility, we charge extra and we deal with criminal lawyers. In this case, what we do at AnyVisa, we very professionally approach the issue of medical inadmissibility, and we contract. We have a good database and contract relationship and good actual personal relationship with lawyers who deal with medical inadmissibility, with doctors who deal with immigration, medical inadmissibility, and qualified to talk about it. They call themselves experts, and we call them experts. And expert opinion is very highly valued, but we have to proceed separately on top and outside of our regular immigration process, which means the cost may be additional, will be additional. So, but maybe in the range of well, I'm not going to give you the number because different sickness require different examination, different situation, different country. Sometimes we communicate with doctors on the ground. Sometimes we deal only with Canadian doctors, but without Canadian expert, government of Canada will not just simply blindly trust your local doctor. So be aware that many lawyers, unfortunately, and consultants especially, they are guilty of lying to people that it's okay, you can proceed as it is. Remember, if they ignore your problem, they probably have a reason, and usually it's financial reason. You pay the money, you never see some help from them, and you on your own. So with AnyVisa, you at least know that we are experts in this. We deal with multiple cases on a regular basis, and definitely we go with a full-scale offensive on immigration service because we need to bring you here. This is our task. This is what you retain us for. One of the new instruments that we observe in government arsenal, because they also flexible and fluid and grow in their proceeding. So they identify the mitigation plan, which because before we did it ourselves, we just kind of pull our expertise together. We pull together our knowledge and data and experience and due diligence, and then we presented the case to immigration. Now at least they have this what they call mitigation. So mitigation itself is not that difficult to provide. But again, if you don't know how it works, this is the page dedicated to mitigation plans for excessive demand. If you don't know how it's done, it's very difficult to actually produce a good, viable, and comprehensive and acceptable mitigation plan. In a short term, I can explain that we have to provide an explanation how actually you support your future expenses related to your medication or health condition or treatments and caring you for yourself or for your loved one. your dependents, prescription medication, social services. You can read this page yourself. I'm not reading it to you. You are very eloquent in English, of all of you, and you can read for yourself. But remember, the bottom line, publicly funded health services in Canada not obligated to take care of your situation if you immigrate here as independent immigrant. And that's exactly how you all immigrate, unless you are sponsored by your loved ones or you are a refugee. So how to prepare? Well, technically, we have own recipe much more in depth than this one, but in a nutshell, the plan must show what kind of services you need, how you will pay for this, and how your financial situation today reflects it. Because sometimes people say, well, I will have a job and I will definitely be able to pay. No, that's not how it's going to work. On top of your regular settlement funds, of course, you have to produce your amount corresponding with a financial threshold. So, once you're ready with settlement plan, once you're ready with mitigation plan, of course, it's easier to feel comfortable. And that's exactly our goal today, to make you feel comfortable, to make you absolutely feel confident that you are in good hands, in good shape, and don't panic. Of course, this video as instructional video, as suggestive video, cannot be treated as final legal advice. That's my legal disclaimer to you. But you can leave your comment below if you face medical inadmissibility at some point, if you're watching us among our viewers. And if you're not subscribed yet, please subscribe. Like this video, share it with someone you think may benefit from this. And of course, stay safe by staying informed.